Of the Commission, Chair.
Yeah.
Yes.
Yes.
Chair, the matter that has just been called is allocated under SEQ 18 of 2020. It's an application by Siangena Technologies and others to cross-examine Mr. Ollerman. Yesterday, on the 14th of June, we have been finished with the notice of withdrawal. As it stands, the matter has been withdrawn. The application has been withdrawn.
Yes, I've seen the correspondence. Thank you. So that matter has been withdrawn. Thank you.
Thank you, Chair.
Next matter.
Khamanyane and Sisoko.
And I think, Registrar, for the sake of the record, do also mention the SEQ number, just for the record. This one is SEQ 09/2020, is that correct? Is that correct? Yeah.
Yes.
Okay. Any appearances here? Yes. Okay. Well, the applicant must then address me. You appear for the LEA workstream legal team. Okay, all right. Let me start with the applicant. They will sanitize. They must sanitize before you use the podium.
Chairperson.
Yes, just for the record, you will just have to place yourself on record so that the record reflects who appeared, and then we can start. Not that I don't know you. I do know you, but for the record, let the record show who appeared.
It shows who appears, indeed,
Yes.
indeed, Chairperson. My name is William Mukari, SC. As it has been pointed out already, I am appearing for Mr. Khamanyane in respect of the allegations that were made during the course of the hearings of the Commission by Mr. McBride, Mr. Sisoko, and Mr. Kuba. All three were at the relevant times employees of IPID.
Yes.
And Mr. Khamanyane was at some point appointed to act in the position that was occupied by Mr. McBride, which is Executive Director of IPID.
I think that, Mr. Mkhari, a lot that you will say in support of this application is likely to be the same thing that you will say in regard to his application to cross-examine, for leave to cross-examine the other two. The registrar mentioned the Sisoko matter only, but you are right that he also applied for leave to cross-examine Mr. McBride as well as Ms. Kuba, is that right?
Yes, indeed. In fact, the registrar mentioned Khamanyane, Sisoko, and Kuba. So she mentioned all three of them.
All three. Okay, no, that's fine.
And I'm happy to deal with them at once.
No, I
because
think that is convenient. I think
Yes.
that is convenient, but she must just give me all of them. Registrar, are you giving me new files, or are you giving me files that I've been keeping, which I've got my notes? I need files that have got my notes. Is this the one? Okay. All right. Let me mention to you, Mr. Mkhari, a consideration that applies not only to your client's application, but it also applies to applications brought by other applicants in regard to other witnesses, but which fall within what we in the Commission call the law enforcement agencies, LEA. That includes, that relates to iPad, that relates to the Hawks, that relates to the NPA. Paragraph 7, I think it is, of the terms of reference of the Commission give power to the chairperson to refer some matters that the Commission would otherwise investigate to that paragraph gives the chairperson the power to refer some of the matters to law enforcement agencies for further investigation, or to what it refers to as the convening of a separate inquiry. The understanding is that what was contemplated is that there may be matters that this commission might not be able to get to, and it might decide that they must be referred to law enforcement agencies for further investigation, or to a separate inquiry for further investigation. Now, on my understanding, that could be matters where the commission didn't get to do any investigation at all, or it could be matters where the commission was able to start investigation but couldn't finish. So that is the understanding of that paragraph that I have. Now, the law enforcement agencies, that work stream is a work stream that will be referred to the fora mentioned in paragraph 7, or a recommendation may be made to the president to establish other processes for purposes of investigating allegations that have been made under those bodies, law enforcement agencies, IPED, NPA, Hawks, and so on. So, in regard to IPED, the commission, as you know, did listen to various witnesses, including Mr. McBride, Mr. Kuba, and Mr. Sissoko, and they gave their evidence, and various persons were served with 3 notices, including your client. And at a certain stage, it was envisaged that they might all give evidence. But the fact of the matter is that it's quite a wide investigation that needs to be done, and that this commission is not going to complete the investigation in regard to these agencies. So, therefore, because the commission is not going to complete the investigation, it can't make any adverse findings against anybody, because obviously that would not be fair and that would not be proper. So what I envisage is that whatever other forum or process will look at these allegations and investigate further, that forum or those bodies which will investigate would look at whatever the commission had been placed before the commission and do further investigation based on that. And in appropriate cases, they would want to hear people who are implicated, which would include somebody like your client who wanted to say something, but couldn't say it because the commission did not pursue the investigations to completion. So that is the position. So given that understanding, the question arises whether the position shouldn't be that no further investigation should be, or evidence should be had in regard to these bodies, because it's a fact that the commission is not going to complete the investigation. It may as well leave everything to whoever will take the investigation further. And that includes the question of cross-examination. But of course, it may well be that somebody might say, Chairperson, I understand that completely, but maybe here is somebody who came to the commission and said all kinds of things about me, and at least I should have my version put up or something like that. So I think if we're talking about anything along those lines, one could look at the possibility of saying, well, would it not be adequate if an evidence leader of the commission reads out a summary of that person's version in public at a hearing such as this, to say such and such a witness gave evidence and implicated this person in this way. The commission is not going to complete its investigation in this regard, and this person has put up an affidavit, and here is the summary of what he has to say. Whether that kind of balancing would not be adequate. In other words, to the extent that one might say I should not grant leave to cross-examine, seeing that the process of investigation is likely to be taken further by another body, and the person can exercise cross-examination under that body. What do you have to say about this concern?
Yes. Thank you very much, Chairperson. Of course, we do appreciate that the Commission is in no position to finish everything, and especially in the light of the many applications that have been brought by people to cross-examine. So the proposal that you make, I think, it is a sensible one. But what I can propose is the following, and I'll give examples in the context of the Hamanyani and McBride and Sisoko Kuba situation. For instance, in respect of Mr. McBride, he gave a statement, a sworn statement, an affidavit, and the Commission gave Mr. Hamanyani an opportunity to respond. He also filed a sworn statement. So the Commission has the two affidavits.
All versions, yeah.
Yes, so both versions are there. And if the Commission, for instance, is going to, because I wouldn't prefer the Commission not to say anything at all about what was said, for the sake of the fact that some of the things were said in public, and the report is going to be made public to those interested. So the Commission should still be able to deal with that which was put by the respective individuals under oath and consider whether what has been said by each of them is supported by objective evidence. Let me give an example where Mr. McBride put a statement which is based on what he was told by other people. So basically, strictly speaking, if we're talking the law of evidence, one will say that this evidence is inadmissible unless the probative value of it is supported by the persons from whom it comes from. So if then the commission is unable to find any corroboration from Kuba and Sissoko on what he has said, so the commission will have to reject it because at some point it has to apply that test. But to the extent that it is supported by what they say, then the commission will look at what Khamanyane has said in his own statement and whether what Khamanyane say in his statement is corroborated by the documents that he has attached to his statement. So at the end, if the commission applies that test, it may even come to a conclusion that in respect of certain matters, if one were to apply the test that we normally use in motion proceedings, that it is so far-fetched that the commission must reject it outright because it has no merit. So there's no need even to say that it must go for further investigation because it is to burden other fora with unnecessary material. But where then the commission will find that there is some merit which require further investigation, it will do so. So if that is what the commission is going to do, we'll have no problem with that because the commission will see when considering the affidavit of Mr. McBride that everything that he says is that he was told by people because he says, I never met Khamanyane. When Khamanyane was appointed to act in my position, I was on suspension. So they never met. So whatever he's saying about Khamanyane is what he was told by other people. And those people that he's talking about is Kuba and Sissoko. And when you come to Sissoko and Kuba, then the commission will look at what they say about what McBride has said about them. And if there is no correlation, then the commission will simply then not take that as something of substance which requires further investigation. So I think that if the commission is going to approach it that way, it will help the commission also in terms of its time pressures that it will not be able to finish the investigation. And I would say that from the side of my client, then I don't think he will have a problem with that, knowing that there is no risk of any adverse finding made against him, but also knowing that what he has put under oath in his own statement, supported by documentary evidence, will be taken into account by the commission. And when the report comes out, it will also have that analysis. So I think that he will not have any problem if that type of an approach is followed. Because our concern was a situation where allegations were made and they were carried to the public through media platforms. And the public will ask and say, but we have not heard what Khamanyane said, what Khamanyane's response is. But if the public knows that Khamanyane did put a version, although it is by way of an affidavit, and he was available to testify to rebut whatever was said about him, but because of the time pressures and because of the discretion of the commission in terms of paragraph 7 of the terms of reference, that it has that latitude to refer certain matters for further investigation, then I think that people will know that whatever was said about Khamanyane by McBride, by Sissoko, by Kuba, does not necessarily reflect the truth, but the converse may actually be the truth. So I think under those circumstances, we think that we can be accommodative, knowing that we have that comfort.
Yes, yes. No, I think that would be good. I think I think the bottom line would be that since the commission would be regarding the matters as not having been fully investigated, it would then approach the matter on the basis that the matter or matters may need further investigation, and therefore it would be not be fair to make some finding when there is still going to be another process. And of course, to the extent that the commission would say anything about the allegations or evidence that has been led, it would have regard to all versions that are before it. So that would be the position. So if your client is able to live with that and accept that scenario, it would seem to me, therefore, that there is no need to go into cross-examination. There is no need to grant leave. So, but on the understanding that the investigations not having been completed, there can't be adverse findings.
Yes.
Findings must be made when the investigations have been completed. So I think we are on the same page.
Yeah, I think we're on the same page. I then
Yes.
understand that.
Yes. No, thank you. I think in that situation we are therefore faced with, in terms of formalities, either that you withdraw the application or I dismiss it, but this is the understanding in terms of the investigation not having been completed. Which
Well,
one
I
would you
think,
prefer?
I think all what the commission has to say is to say that in respect of matters involving law enforcement, of course,
Yeah.
the chairperson will have to hear others because I understand there are others.
Yeah.
The commission is not in a position to investigate these matters fully, and therefore it is likely to refer them for further investigation.
Yeah.
And for that reason,
Yeah.
it will not consider the applications
Yeah.
to cross-examine.
Yeah.
Yes.
Well, I don't know whether it's correct to leave it at it will not consider, because it's like they are hanging in the air. We know where,
Okay, now I understand what I'm saying. I understand what I'm saying. So basically then, I mean,
because
the
maybe
long
I
and
can-
short of it is that the
Yes.
application is withdrawn
Yeah.
for the reasons given.
for the
Yes.
reasons given.
That's
Yeah.
right, yes.
Okay, no, thank you. So that is the position, and I appreciate your cooperation and your understanding.
Thank you, Chairperson.
Thank you. So that covers the three matters.
Yes, the three matters that is now Hamanyani in respect of McBride, Sissoko, and Kuba.
Yes, okay, no.
Thank you, Chairperson.
Please call the next matter.
Mr. Kigaba and Mr. Bishop, SCQ 5 of 2021.
Good afternoon, Chairperson. Mr. Myberg of the Commission standing in for Ms. Sabia
Yes,
of the legal team from Alex Corp.
yes,
Chairperson, you know that this is an application brought by Mr. Gigaba to cross-examine Mr. Bishop. It arises in the Alex Corp stream. I understand that you are aware that earlier today we received from the State Attorney on behalf of Mr. Gigaba a notice of withdrawal of the application.
yes, I'm aware, so this application has been withdrawn. Okay,
Thank you, Chairperson. May I be excused?
Yes, you are
Thank you.
excused. Thank you. Please call the next one. Just raise your voice. I'm not sure that everybody can hear you. Or is your mic not working? It's the matter of Mr. Claudi Mutsoneng, who applies for leave to cross-examine Mr. Karim, SEQ 16/2020. Yes. Yes. Yes.
The Q16
Yes.
of 2020,
Yes.
which is the one that is you're currently seized with.
Yeah.
And the second one is the one pertaining to the leave or application to cross-examine Ms. Lulama Mkubo, the former CEO of the SABC.
Yes, but let's deal with the number 16 first.
Yes, indeed, Chair.
Okay.
Yeah. Chair, I don't know if you are in receipt of the applicant's heads of arguments in respect of this matter.
They may have reached my office, but I didn't get a chance to
Okay.
read them. I was told that there were matters where written submissions had arrived sometime today. I see that there are heads of argument. This is the matter relating to Mr. Karim. My recollection is that in both matters, Mr. Mzoneng wanted to cross-examine on very narrow points.
Yes, indeed, it's very narrow points, and they can be easily disposed of without.
What is the dispute of fact or the disputes of fact that he is complaining about here?
Okay, let me just address you quickly. I think it was. Okay, the disputes of facts are quite narrow, and they're identified in the founding papers of the applicant under the heading disputed facts.
Yeah.
Also, on the heads, I can just address you. They are also reinforced and encompassed as a corollary to the application for cross-examination.
In your written submissions, is that what you deal with at page 2 as Mr. Mutsoneng's rendition issues? No, that's not your heads of argument.
Okay. The disputed facts, Chairperson, are on the comments on paragraph 29 of the heads of argument.
Okay, I'm sorry, I've moved to the affidavit. Just take me to the affidavit again.
Oh, to the affidavit quickly. Let me just, because my laptop was a bit frozen. Let me just get you there.
I see at page 11, paragraph 35 of Mr. Mtsoneng's affidavit. So he says, the disputed facts identified in the affidavit of Mr. Yunus Karim.
Yes, indeed.
Yeah, just run through them quickly for me.
Yes. One of the, I think it's easier because they are, anyway, they're regurgitated in the heads. I'll just quickly go to the heads.
Yeah, okay.
One of the major issues is pertaining to the issue of the encryption model of the SABC, wherein multi-choice, the multi-choice deal, just to put it bluntly.
Yeah.
And if you look at Mr. Karim's evidence before this forum, which the applicant takes aversion to, was opportunistic and malicious to the integrity and reputation of the applicant, as you will see, and not just to quickly address you on the points of
I
dispute.
think what I'm really looking for is that this is what Mr. Karim says, and this is what
Mr. Mutsoeneng
says
says.
in regard to that point.
Yes.
You know, that's going to be much easier.
Yes, that's what I'm
You are trying to
to address you on.
Okay, all
Chair.
right.
Because I don't want to bedevil you and waste
Yes.
the Commission's time in
Yeah.
that regard.
Yeah.
So if you look at the issue was about to do with the STB control and encryption. Remember, Chair, I don't know if you recollect the testimony of Mr. Kruger, who spoke at length on the issue of encryption. And remember, if I can take you a few steps or a few years back, you were part of the quorum of the Constitutional Court that gave judgment pertaining to the encryption to say that the cabinet was correct in adopting the approach it did adopt in addressing the encryption issues.
Yes.
And so now it's surprising that then Mr. Karim, when he's before this forum, he takes an about decisions that were taken when he was not yet minister. So those decisions are the decisions that we're saying that it's a dispute of fact.
To know what factual statements did Mr. Karim say about Mr. Mswaneng that Mr. Mswaneng disputes?
Well, one of contention is that Mr. Karim says that it is Mr. Mswaneng who was anti-encryption. That's a dispute of fact, because Mr. Mswaneng was never anti-encryption. This was a decision taken by government, the cabinet, which was mandated to take the decision thereof.
Yes.
So it will not augur well for the interest of this commission if that evidence is to be laid bare and untested through cross-examination.
Right.
Yes.
Okay. Of course, Mr. Mswaneng was neither the minister nor the CEO of
the SABC.
SABC.
Yes, indeed.
And that may raise the question of, even if it may be said that he was anti, the question might arise, why is it so important that we should go into that and have cross-examination when he was not even the head of the SABC?
It's because also the head of the SABC, remember I said that's why earlier on I referred you to the leave to for the application to cross-examine Ms. Lulama Mkobo.
Yes.
Mrs. Lulama Mkobo's evidence is in tandem with Mr. Karim's evidence. And remember, she was the erstwhile CEO of the SABC. And she also opportunistically and generously implicates Mr. Hlaudi Mswaneng for misdeeds, which misdeeds Mr. Hlaudi Mswaneng did not commit. If anything, the person who abrogated their fiduciary duties is Ms. Lulama Mkobo. So now, if you look at the evidence of Ms. Lulama Mkobo before this forum, which she gave not only on affidavit, but orally, those are not in sync with the general accepted issues like what you are placing before this forum, Chair, to say that Mr. Mswaneng was neither the CEO nor was he a member of cabinet pertaining to these issues.
But I would imagine that when Mr. Mswaneng gave evidence, he dealt with that as well, isn't it?
He did deal with the issues on the 12th of September 2019, but remember, we then packed his evidence after there were a number of issues that he wanted to address this commission on. And remember, you granted him leave to supplement his evidence which supplementary affidavits were served and still served before this forum.
Yes,
And he has still to testify on those supplementary affidavits. And furthermore, the other arresting issue that needs to be placed before this forum is that whilst in the process of bringing that information before this forum, that's when there was this long queue of people now coming to implicate him. So it was like as if it was now Mr. Mtsoneng was now fodder for the general public, that anyone, and Jack and Jill can come and implicate him. So it won't augur well for the interest of this commission if that evidence is to be ignored, or let alone for the commission to accept it as the truth.
So your answer is he did testify about it, but orally, but he has also covered it in affidavits.
Yes, covered it in the affidavits, but remember
He just hasn't had another opportunity to
ventilate it.
evidence,
Yes, to
but
ventilate it
otherwise-
before this forum.
Yeah, okay. What were the other factual statements that he takes issue with from Mr. Karim?
One of the issues of Mr. Karim, remember, is about the Channel 24 news channel, which that one, I think it can easily be resolved on paper, but I think suffice to say, just for avoidance of doubt, I think it's best that I also address you on that issue, because the News 24 channel was not only sanctioned by Mr. Karim himself, but also by Ms. Lulama Mkobo. There's YouTube.
What did Karim say about News 24?
He's saying that this was what Mr. Karim says, that it was a decision that was arrived at by multi-choice. By I think there was involvement of Mr. Imtiaz Patel pertaining to that issue, and then secondly, the issue was also that, according to Ms. Lulama Mkobo, she was never part of that decision. But if you look at the board resolutions and the board minutes and the YouTube video clips, remember there was the time when we had a tita-tata pertaining to the YouTube videos, and you were saying that they might consume the time of the commission if we were to play them. And we said that we'll only go to that portion where she even makes congratulatory messages and pats herself on the back pertaining to the News 24 channel. So I don't know whether there's a form of amnesia on her part and Mr. Karim's, or it's just unwittingly or wittingly avoiding putting the truth before this commission.
But what did Mr. Karim say about Mr. Mtsoneng in regard to that channel that Mr. Mtsoneng takes issue with?
He said that Mr. Mtsoneng was the one who was responsible for it. Mr. Mtsoneng was not responsible for it. It was actually Mr. Karim himself and Ms. Mkobo.
Yes.
Yes.
Okay.
So those are mistruths that can be...
As you were saying, on papers that can be resolved.
They can be resolved on paper. Like I said, we don't want to take much issue on them. Because, I mean, I think those are issues, because in any event, what Mr. Mtsoneng did was, in the application for cross-examination, he did then annex to it the board minutes, the board resolutions, letters between the erstwhile chairperson of the SABC board, who's Dr. Gumbane, and also pertinently, he also attached letters from which were exchanged between the then Minister of Communications, Denapule, and Mr. Karim also as well.
And what other factual statement is he complaining about that was made by Mr. Karim?
I think it's also the other issues, the cut and paste issue of the Sowetan news reports that Mr. Karim went at large before this forum, giving evidence on. Yes.
What was the statement that Mr. Karim made about Mr. Mtsoneng?
What Mr. Karim did was that, remember, if we take a few steps back to the Public Protector's report, that was issued against largely Mr. Motsoeneng pertaining to the maladministration, alleged maladministration and irregularities at the SABC, where aspersions were cast on him, and where, if we can remember pertinently and closely so, what the public protector then says that Mr. Motsoeneng must undergo the rigors of a disciplinary inquiry pertaining to those issues. That disciplinary inquiry never happened. If anything, Mr. Motsoeneng was then assailed in the disciplinary inquiry for making disparatory remarks pertaining to the then erstwhile SABC board. So those issues, I don't want to deal with them because in any event, I'm sure the court seized with the public protector's review application will adequately deal with those issues. So suffice to say, what I can then do and propose before this commission is that those issues, what this forum can then do is to pack or put them in a hiatus, those issues, to say that they're going to, or to say they're not going to deal with those issues since they're going to be playing out anyway in any event in the public protector's review application.
I'll tell you what I propose to do. I propose not to grant him leave to cross-examine, but his version would be taken into account. Matters where evidence or allegations have been made of somebody being involved in acts of state capture and corruption and fraud. Those are matters where I give a lot of weight for purposes of leave to cross-examine. On what you say, you are telling me, it seems that largely it's a question of Mr. Motsoeneng saying somebody has lied about me or something to that effect. This is what they said, it's not true. This is the position. So my intended approach is to say all versions must be taken into account in regard to this matter, and whatever will be done will be based on both versions, but that given all the circumstances, it doesn't seem to me it would be in the interest of justice that I grant him leave to cross-examine on these matters. That's what's in my mind. You want to say something about it?
Yes.
Yes.
I have a bit of a stigmatized nightmare pertaining to that chairperson.
Yes.
And I respectfully say so because
Yes.
it's encroaching onto the applicant's rights before this forum. Remember what was said in the...
I leave out the question of him testifying whatever was left. I leave that out. I'm not affecting that for now.
Yeah, but why I'm saying the nuance of this, of his evidence in any event before this forum is pertaining to his rights to say that people came, they implicated him, and from the manner in which the interrogations were panned out before this forum, it was as if you as the chairperson was readily likely to accept the versions proffered by Mr. Karim and Ms. Mukobo than his version. That's why he has a challenge.
Yeah.
That's why he's saying, I need to, my rights here are fettered unless if I'm granted the leave to cross-examine these individuals who have curiously and in a defamatory manner, that not only, there's one other issue that if you look at the end of our heads, which we also invite this commission to do, to say that if at the end of the day, if you are going to take that exercise and to realize that these two individuals, that is Mr. Karim and Ms. Mukobo, lied before this forum, then would want you as the chairperson to direct whatever ruling or findings that you have made to be taken by the secretary of the commission to the NPA for further investigation and prosecution for perjury. Because you can't have people coming and playing out in the gallery here, lying about individuals' lives. I mean, these are people's lives. Their dignity is shamed.
Let me say this. I mean, I appreciate the impact on individuals of allegations that are being made or are made from time to time in hearings in the commission. I appreciate that. But what I'm saying is that cross-examination, if cross-examination is not granted, it doesn't necessarily mean that there is one side of the story before the commission. There are still two sides or more sides, and the commission would have regard to all of them. Okay. And of course, you will appreciate that by the very nature of the power that has been given to the chairperson to grant leave to cross-examine, it also means he may refuse leave to cross-examine in certain circumstances. And it doesn't mean that where leave to cross-examine hasn't been granted or has not been allowed, where cross-examination has not been allowed, it doesn't necessarily mean that it's an unfair hearing. It all depends on everything. So, one, you can assure Mr. Mtswaneng that no particular witness evidence has been accepted that is disputed, and that which evidence is accepted and which evidence is not accepted is something that will come out in the report finally. So there may be a situation where somebody thinks because the witness is giving evidence in a certain way, or the chairperson seems to be listening very attentively, maybe he's going along with that version. The chairperson has an obligation to listen to every witness and to ask questions. Some witnesses complain that the chairperson is asking too many questions as if he is the evidence leader. So you can assure him. But I was giving you the benefit of what was going on in my mind so that you can address it before we conclude. Yeah. But I think you have addressed it. I don't know if you want
there's
to
just
say one or two
one
things.
issue that lies for your disposition, Chair. I don't want to go into the constitutional debate, but I firmly believe, and my client, the applicant, firmly believes that he has a right, an unfettered right to cross-examination in terms of Section 39(2). I mean, we must promote the spirit and object of the Constitution. We don't want to go into the constitutional debate because we'll consume the Commission's time. But suffice to say that the applicant wants, in the alternative, his notice of motion was that in the event that the leave to cross-examination fails, he be granted leave to lead evidence in rebuttal of the evidence implicating him in terms of Rule 3.3 as read with Rule 3.9 of the Commission's rules.
I think you said earlier on that when he left the witness stand last time, there was an understanding that he may have to come back to deal with certain matters.
That was before the implications.
Yeah. So I think that what will need to be done is to look at the basis on which he left, and to look at the issue of him dealing with the remaining parts orally. So there would be the question of, is it necessary to allow oral evidence to deal with that, or will justice be done even with looking at the versions as put up in affidavits? But that is something that I can look at in due course.
All right. Thank you, Chair.
Right. Okay. So in regard to his application for leave to cross-examine Mr. Karim, the application is dismissed. If reasons are requested, they will be furnished. But with regard to his application for leave to cross-examine Ms. Makobo, we can deal with that.
Yes, thank you,
Okay,
Chair.
I'm sorry. I've not allowed this to be called because you are on the podium, but Mr. Pretorius indicates there is somebody. Yes. Or on the matter that I've disposed of? Or does he represent Mr. Karim? Does he still want to address me? Let me hear what he has to say quickly. So somebody will sanitize, but I have disposed of the matter, but I'll hear what you have to say quickly.
Thank you, Chairperson.
Yes.
I think my presence here may be superfluous now that you've
Well,
actually ruled on the matter.
Yeah, I didn't want to hear anybody.
Yeah, well, that's,
other than-
we would go with that, Mr. Chairperson.
Yes.
Just to place myself on record for Mr.
Yes.
Karim
Yes.
from the law firm Harris Newman Mulabatsi.
Yes.
We have prepared submissions on these issues.
Yes.
I'm not going to, in view of your ruling,
Yeah.
waste your time or take
Yeah.
up any further your time, but we will submit them to you for your consideration.
Yeah, no, that's all right. Thank you. Okay, let me now deal with the matter of Mr. Mutswaneng, who applies for leave to cross-examine Ms. Makobo. Registrar, what case number is that?
SCQ 17 of 2020.
Okay.
Chair, I don't know if this application is going to also suffer the same fate as the preceding application.
I'll tell you what, my recollection in regard to this one is that the whole issue is about the issue of authority.
Yes, indeed.
Is that right?
And she alleges that she was afraid of Mr. Mutswaneng.
That part I don't remember, but I remember.
Well,
that
we remember it vividly.
It was about, the issue about authority. I'm not sure why there should be cross-examination on that issue, because that issue should be resolved by way of somebody submitting a document that shows authority, whether it's a resolution of the board, or it's a delegation of authority, or it's a provision in a statute or regulations, isn't it?
Yes, actually, I wanted to address you on that issue that actually what Ms. Mukobo does, wittingly or unwittingly, she submits in prolixity a number of annexures. I think it's from page 53 to 376 of SEQ 17, where actually the bulk of those annexures actually support the contention of views of Mr. Mutswaneng than her own views. So it's actually a self-defeating exercise on her part. But like you
But
say,
of course,
Chair, I'm in your hands
Yes.
pertaining to that
Because
issue.
if you agree with me, and if you say that the documents that she has submitted show that there was authority, as I say, authority would normally be proven by way of a document.
Yes, yes, indeed.
Yeah.
Because what
Yeah.
Mr. Mutswaneng has done is he has attached to his founding affidavit and also to his replying affidavit
Yes.
a number of annexures that dispel the myth
Yeah.
that the decisions that were not taken in sync with
Yeah.
board resolutions or board decisions.
Yeah.
But to say that these decisions were taken, the board, well knowing that these decisions were taken, and they're taken a vote that these decisions will be taken.
So shouldn't we deal with the matter on the basis that, to the extent that it becomes necessary for me to decide whether there was authority, the documents are there, and the document that he relies on is there, or documents that he relies on are there, and therefore there is no need for him to come and say, you see, this is the document.
Yeah. Yes, Chair, I would agree with you, but I just want to add a further, excuse the pun, a feather in the hat, to say that Mr. Motsweneng would love that in the event that there's to be a negative ruling towards him, that there be a further invitation to say, not because remember you've already fettered his access to cross-examination. So we're saying to ensure that his right to access this forum in terms of Section 34 of the Constitution, and also in terms of Section 9(3) of the Constitution, that the right to equality and the right of equality of arms when pertaining to proffering evidence before this forum. We're saying that you invite him further to say that if there is to be a negative or inference drawings are made against his evidence, that there be a further invitation extended to him to say, perhaps as a way of questions, that these 3 or 4 questions are still outstanding. Can you address us on these questions? Then if we agree on that, then I don't think the applicant will have any challenge with that.
No, I think the approach should be, if he is satisfied that the documents that prove what he wants to prove are before the commission, that should be enough. The commission must have regard to all documents and all affidavits and decide. It might not be necessary to decide whether there was authority or not, but in case it's necessary for the commission to decide that issue, then it can have regard to that.
Chair, the clarion call...
Because otherwise, we will never finish if we say we will invite him at some stage and so on.
No, I understand we need to bring finality to these proceedings. I'm on all fours with you there, Chair. But one thing that remains for ample determination again is the rights of the applicant, which are being circumscribed. Because remember, we've already had volleys of information, evidence churned out before this forum, calling him whatever names, all that has been said about him. I don't want to go into that debate. But what I'm just saying is that what then happens to his rights was we're trying to also put as a safeguard mechanism the issue of that in the event that the evidence is not overlooked.
No.
Because remember, the evidence is before the forum, but what guarantee do we have that the evidence will not be overlooked?
No.
That's all I'm...
All evidence that is before the commission will be looked at. You can't assume or want a guarantee of anything other than that the commission will apply its mind to the evidence before it. So the commission will apply its mind to evidence before it and decide issues that it believes it should decide. Some of the issues that the parties might think it will need to decide might be issues that it decides they are not important to decide. But as far as the issue of authority, I think we are agreed that usually that should be shown by way of documents, and you have already said the documents that have been put up actually by Ms. Makobo seems, you say, support Mr. Motsweneng.
Yes. And then there's also the last remaining determination, which is similar to the one that I addressed you to in the Karim application, the issue pertaining to perjury, that in the event that she's found to have misled this forum, consequences must take place. In other words, the secretary of this commission must be directed to place that evidence before the NPA.
When the report is filed and is made public, the secretary of the commission will have no power anymore. The commission will have ended because the report must go to the president, you remember? And it doesn't immediately become public. It will wait for some time until the president decides to make it public. By that time, I believe the secretary won't be there, the staff won't be there, will be done. But obviously, it is up to the chairperson in regard to anybody that he may find has committed perjury. It is up to the chairperson to draw that to the attention of the law enforcement agencies if,
Yes.
if he should consider that that is what should be.
Yes,
be
precisely,
done.
Chair. Yeah.
Okay, all right. Okay, so on the basis that we have discussed, I would therefore dismiss this application, and it's on the basis that the question of authority should be dealt with by way of affidavit. It might not need cross-examination. Okay, all right.
Yeah.
Thank you.
Thank you, Chair. That will be my
Those will be
role.
your matters.
Yeah, that will be my role, Chair.
You are excused if you wish to be excused.
Thank you, Chair. I'm indebted, Chair.
Thank you. Please call the next matter.
Mr. O'Sullivan, in respect of the evidence of Mr. Montana.
Chair, on
Yes.
behalf of PRASA legal team, I just need to put on record,
PRASA Workstream Legal
Workstream.
Team. If you say PRASA Legal Team, it means you represent PRASA.
PRASA Workstream of the
Yeah.
Commission. I want to put on record that the matter has been postponed.
Yes, okay. This application has been postponed. Thank you.
Thank you.
Yes, next matter.
Advocate Mkhwebi, in respect of the evidence of Mr. Agrisi.
You didn't mention the SEQ number, did you? Registrar?
SCQ 59 of 2019.
Yes, Mr. Harley.
Thank you, Mr. Chairperson. Mr. Chair, I'm standing in on behalf of the Bosasa workstream. I understand that from the papers that have been filed by Mr. Mkhwebi that it was his intention to apply for leave to cross-examine Mr. Agrisi. Recent correspondence between Mr. Mkhwebi and the Secretariat suggests that there may be some doubt and there might be some confusion as to whether that is indeed his intention. I'm not sure if my understanding is correct. Mr. Mkhwebi was intending to link up.
Is
via
he
a virtual
represented
platform.
here today? Is he represented here? Is
He's
somebody
not,
here?
my understanding was that he was at one stage represented, but he's no longer represented.
Yes. So, have you got the correspondence that makes you say it's not clear whether he intended
If
to
I can
apply
direct
for
your
leave to
attention,
cross-examine?
Mr. Chair, to page 521.
What page?
Page 521 of the bundle.
Yes.
And what he says is, and there's correspondence which precedes this, but in terms of the pagination system, it actually runs in the opposite order. But to take you to the most recent correspondence on the subject at page 521, you will see there's an email, and the email purports to be from a Malcolmes Umedi. But at the end of the email, you'll see that it's in fact Advocate Mkhwebi who has used that email address. The
I'm
address
sorry,
is-
just repeat the point you're making. I'm not sure that I followed. I was trying to see what he says
What
here.
he says, if I can take you to the body of the email, he says, please provide me with a copy of and any accompanying documentation of any formal application made by me on my behalf to cross-examine Agritzi and advise who made such application, when was it made, and what was the Commission's response to such application. So in other words, what he appears to be suggesting is that if such an application had been made, it was not in fact made by him. The purport, or the import, or rather, of what he conveys is that he doesn't seem to be the author of such an application. However, that's not supported by the actual body of the document itself, because there is, in fact, if you would consider page 1 of the same bundle, you will see there that there's an application for the extension, it says extension to give evidence and cross-examine witnesses. That document is, in fact, unsigned, but if you turn to page 3, it purports to be a document that has been prepared by Lawrence S. Mkhwebi, and it's dated the 14th of February of 2009. If I can then also take you to the actual statement, which commences at page 7 of that bundle, and take you to page 44. You will see there that there purports to be a signature at the foot of the page. It's signed by Advocate Lawrence Mkhwebi, and it's dated the 16th of March of 2019. If you look at paragraph 86 on that very page.
But maybe just, what is the upshot of this correspondence? I see that here at page 521, he seems to suggest that he never made any application, and that's what you are dealing with by referring to page 1, but I see there is other correspondence. What was the last correspondence he sent? What did you say?
The most recent correspondence from him is that which appears at page 521, to which I took you to previously, Mr. Chair.
Oh, okay.
So that's the most recent correspondence from him.
Well, I see that at 522, which was the previous day, he says, he seems to suggest that he didn't receive a notice of set down, but at 521, the subject is El Mkhwebi versus Agritzi, SAQ number 59/2019, stroke notice of set down. He says at the end, but importantly for me, I've never made any formal application to cross-examine Agritzi. If such was made on my behalf, please provide the details and supporting. Seems to me that I must just dismiss the application.
It seems so. We would have, in any event, made such a submission.
Yes. This application is dismissed.
Thank you.
Okay. Next matter.
Advocate Morsing, in respect of the evidence of Mr. McBride, Colonel Deploy, Mr. White, Mr. Kuba, Mr. Sissoko, Mr. Boyson, and Mr. Molochwa. SCQ 47 of 2020.
Yes. Please switch on your mic so we can hear you.
Thanks, Chairperson.
Yes.
Chairperson, Matibedi, together with Advocate Vilagasi, Ramaimela, and Matlanga,
Yes.
we appear for the applicant.
Yes.
Chairperson, you will note that there are other 3 matters of a similar nature.
Yes.
Which are set down for today.
Yes.
And also there are other 4 matters which are set down for tomorrow of a
Yes.
similar nature.
Yes.
Chairperson, I've heard your sentiments that you
Yes.
have advanced.
Yes.
In the circumstances, I'm going to ask that this matter stand down to tomorrow so that the legal team should have an inclusive consultation with other affected, implicated officials in the NPA.
Yes.
To convey what the chairperson said today.
Yes. Okay, no, that's fine. I had been told that there was a request to move them to tomorrow, but I thought that we should rather use as much of today as possible. But in the light of what you are saying, that you need to consult in regard to the issues I've raised, I think that that's fair enough. We can agenda them to tomorrow. So that would be, do you want to just for the record mention all those matters that you are asking me to agenda to tomorrow?
It is Advocate Musing, Baloyi, Mokhatle, and Mashucha.
Yes. Okay, all right. Those matters are agenda to tomorrow.
As it pleases the
Okay.
chairperson.
Thank you.
May I be excused?
You are excused. So, Registrar, you'll just have to note those so you don't call them again. I just wish to take a short adjournment. There is a heater at my feet, but it has not been switched on. So I would like to give an opportunity to somebody to switch it on. So we'll adjourn for about 5 minutes. We adjourn.
Service, as well as the investigation office, should get together with the team from the NPA
I
to
seem
see.
to remember that
Yes.
actually what seems to have transpired is that Mr. Pahlane, at least according to his version as well as the version of at least one other witness, that he seemed to try to help.
Correct.
He seemed to try to help.
Yes, Chair.
Yes.
Yes. Now, in that respect, Chair, the affidavit of Mr. Pahlane dealing specifically with that matter, we are of the considered view, Chair, that it should be dealt with on
By way
paper.
of affidavit.
Correct, Chair.
Yes.
But-
I would think that is what should happen too. Yeah.
Yes, thank you, Chair.
Okay.
Now we turn to,
So that was the only issue relating to Mr. Rulofse.
Correct,
Is that right? Yeah.
Correct.
Yeah, no, in that situation, as I say, I do have a recollection.
yes,
That he said he tried to help and he was corroborated in this regard by at least one witness. And if you say it's Mr. Rulofse, then
well, Chair,
understand.
actually, Mr. Rulofse was contradicting himself. When he
Yes.
was pressed by Ms. September for the commission to say, are you now changing your position? He said, I have never said that General Pahlane was part of the people who resisted or who refused to assist. But he deposed to a statement following his testimony, stating that indeed he did. But there is no evidence from Colonel Rulofse proving that he ever communicated with Mr. Pahlane in any form requesting information. And in that respect, Chair, his evidence stands to be doubted or rejected, as it were.
And the matter doesn't really need cross-examination.
Indeed, Chair.
Yes.
Yeah.
Okay, no, I think that makes sense. At the level of formality, what would you like us to do with it? Would you like to withdraw it, or do you?
It will be dealt with on paper, Chair.
Yes, so that there is no need to grant leave to cross-examine.
Correct, Chair.
Okay, all right.
Yes.
So this matter will be dealt with without cross-examination.
Thank you, Chair.
Okay, all right. And then we deal with the one relating to Mr. Sissoko.
Correct, Chair.
I did see, I was shown correspondence which reflects the sentiment you have expressed from, I think, those instructing you.
Yes,
because,
that's BDK, Chair.
Yes.
Yes.
Because you recently received a letter which indicated an outcome that may have appeared as at odds with the earlier decision.
Correct. That is
Yes.
dated 15 April 2021.
Yes.
And this time it's from Professor Itumele Musala, who's the secretary.
Yes.
It is specific, Chair, this one. It goes,
Yeah, it relates to specific allegations.
the matter of rendition.
Yes.
Correct,
yes.
Chair. Yes.
And the response, as I recall, was that we have no issue with the issue of rendition. We applied to cross-examine on something else and we were granted leave already.
Correct, Chair.
That's my understanding.
Correct. Because the testimony of Mr. Sissoko
Yeah.
in no way implicated General Pahlane.
Yes.
That he was part of the people who perhaps instigated the arrest of Anwar Dramat and Mr. Sbia.
Yes.
And there is no substance
Yeah,
in-
I think what happened, as you would have seen, that the latest one was quite specific. There was some difficulty in understanding certain parts of Mr. Pahlane's affidavit, and that led to that. But I think in the light of the response from BDK, your instructing attorneys, that whatever that decision is, it doesn't really adversely affect your client because he never sought to cross-examine in regard to Mr. Sissogo.
Yes, Chair. Yes, Chair.
And my approach, therefore, would be that in regard to the matters which are covered by the order that was already granted in favor of your client, that must still be carried out, and the two are not in conflict, as I see it.
Thank you very much.
Would that be fine with you?
That will be super.
Yes. What I can mention to you is that the commission might give your client an opportunity before the end of June.
We will appreciate that, Chair.
To cross-examine.
We will appreciate it.
Your client could be ready anytime.
We would appreciate that, Chair.
Okay, all right. So there is no need to make any decision on this one because the order was already granted.
Correct, Chair.
Okay, thank you. Thank you. Okay. Next matter.
Mr. van Lochenberg, in respect of the evidence of Mr. Montana, SCQ 49 of 2020.
Chair, this next matter is an application that is brought by Mr. van Lochenberg to examine Mr. Montana. Yesterday on the 14th, we received an email from Mr. van Lochenberg requesting that his application be withdrawn, that he does not want to pursue the application to cross-examine Mr. Montana. Yes.
Yes, I am aware of the correspondence, so the withdrawal is noted.
Yes, Chair.
Thank you.
Thank you.
The next matter is Hamanyane that has been dealt with. That is Mr. Hamanyane's application for leave to cross-examine Mr. McBride. Then you can call the next matter, Registrar.
Mr. Kwele, in respect of the evidence of Mr. Sheikh and Mr. Njenje, SCQ 11 of 2020.
Is there any appearance? Okay.
Chair, good evening.
Good evening, Mr. Semenya.
I appear in this matter on behalf of Mr. Kwele, and might I immediately indicate to the Chair.
I'm sorry, Mr. Semenya, please just pull the mic closer to you. Yeah, so I can hear you. Your voice is soft by its nature, so when the mic is far away, I won't hear you.
Heeded, Chair.
Yeah.
I'm representing Mr. Kwele and in this application.
Yes.
I
I understand there are two applications actually, is that right?
That's correct.
Yeah, okay.
I have given my learned colleague, Mr. Pretorius, a copy of a document I beg leave to hand up to you, Chair.
Yes, okay.
The document
Yes.
does no more, Chair, in paragraph 1, 2, 3, it's just a background of why we are here today.
Yes.
I think in the light of the exchange, Chair, you have had with various other people before us,
Yeah.
I might just point you to paragraph 5, which you'll find on the following page,
Yes.
addressing the Mr. Sheikh application.
Yes.
There we are pointing to areas of his evidence that we say require testing. And we say the allegations by Mr. Sheikh alleging that Dr. Twele had anything to do with the protection services that were offered to his ex-wife during her trial requires further probing. Chair, you recall, this is where they say that he, as a minister, took it a responsibility for the protective service for his ex-wife then. And we say that is not correct, it requires probing. Under 6, we say, with the leave of and direction of you, Chair, an intelligence report involving the role of Mr. Sheikh with foreign intelligence services, what we call the UK report, would be required to deal with the actual reasons precipitating the resignation of Mr. Sheikh. You would recall Mr. Sheikh's evidence is that he resigned because the environment was made totally intolerable for him,
Maqetuga.
Yes.
Maqetuga.
Yes, Chair, as well as Mr. Njenje. So it is a classified document. We would think if we are granted leave to cross-examine, it might be helpful for you, Chair, to give directions about our access to this and the access by the Commission of this document. Under 7, we say there are allegations by Mr. Sheikh regarding a meeting with Dr. Twele in Cape Town, where Mr. Sheikh alleges that Dr. Twele instructed the investigation into the Gupta family and their relationship with the then President of the Republic of South Africa, Mr. J. Zuma, be discontinued. We say that requires further interrogation because the suggestion is the intelligence services were stopped from doing what the law says is their responsibility, and they were being stopped by the minister at the time. We say this also requires further interrogation. Under 8, we say Mr. Sheikh also alleges that Dr. Twele was micromanaging the SSA for intelligence. And we say further clarity would need to be sought in cross-examination regarding this matter. I might as well deal with the other one of Mr. Njenje, which we address under paragraph 9.
One of these was, I think one of these, if I'm not mistaken, was filed way out of time, isn't it? One of these applications. One of his applications, was it not filed way out of time? I think there are 2 applications for leave to cross-examine.
Yes, Chair.
I think one might have been filed on time, or if it was out of time, it wasn't so late. But I'm under the impression that another one was filed way out of time. The normal time would be 14 days after receipt of 3-3 notice. Am I mistaken about that?
Well, the timelines are correct, Chair. I'm not alive to the fact that any of this application was late, but
Yes.
then it would be a matter requiring condonation, an application for condonation, I don't know.
I think he does apply for condonation, but it's very brief. I think he says he had challenges in terms of funds. That's why he was late. But I think that's about all, if I'm not mistaken. But he may be late by 9 months or more, I'm not sure. Mr. Pretorius, am I mistaken about one of these being late, very late? I'm sorry, they must just sanitize for you.
Chair, the 3-3 notices were sent to Ambassador Clele on the 12th of November 2019. The application to cross-examine, that is the first application, was made on the 21st of January 2020, some 10 weeks later. There was no application for condonation in that application. The second application to cross-examine Messrs. Sheikh and Ginger and Maktatuka was made on the 5th of August 2020. It seems a renewed application. Condonation was sought. It appears in paragraph 23 on page 27 of the bundle. No real grounds are set out for condonation, save to say that he was strapped for funds and couldn't bring the application earlier. But that doesn't explain why there was an application some 8 months earlier, presumably funded. So the application for cross-examination does not really carry with it an adequate explanation for condonation. If the application is to be granted, it would have to be granted on quite strong other grounds, or overriding other grounds.
There was the first application that was for leave to cross-examine only one of the 3 witnesses.
No,
right?
two. Chair.
On both occasions, it's 2.
Well, on the second occasion, there was the third person, Maktatuka.
Oh, okay.
But I understand the application now, in any event, to be in respect of Messrs. Njenje and Sheikh only.
Yes.
So that third person can fall away.
Yes.
So the application in respect of the 2 witnesses, in respect of whom cross-examination is now sought, was brought first on the 21st of January 2020 by attorneys, and secondly on the 5th of August 2020. On the 5th of August 2020, the condonation for the late filing of the second application was sought on the basis that there were no funds. But it appears that there were funds for an application 8 months earlier.
And the period on the second application of delay was about how long? How many months?
About 9 months.
About 9 months. Okay, and the previous one, 10 weeks, more or
10
less.
weeks, yes.
Yeah. Okay, all right.
I thank my colleague for the information he's provided, Chair.
Yes.
Ultimately, Chair, it lies in the Chair's discretion.
Yeah.
Whether to condone or not. And perhaps the more compelling reason why condonation ought to be granted, Chair, is that this is, in our judgment, a matter of grave public interest. And we think the evidence given anent Dr. Kwele is of a nature that, if undisturbed, if unperturbed, may yield an outcome very prejudicial to the purpose of the recommendations which this commission ought to make at the end of the day. I would, yes.
Well, to the extent that one can say that the condonation application covers both witnesses, covers him, that is the applicant, in regard to both witnesses. In other words, if we are to disregard the first application, which, as I understand from Mr. Pretorius, did not have any condonation application, even though it was 10 weeks late, and we take the latter one, which was late by a longer period, but nevertheless did have an application for condonation, although maybe one would have hoped for a more detailed explanation. Then one can say, well, there is an application for condonation, and then there's a question of whether it's adequate for that length of delay. What I can say is that I do think that Dr. Kwele should be given an opportunity to put his version before the commission. And I am aware that the commission is taking steps to see if he can give evidence to put his side of the story. Therefore, if that is what is going to happen, he will get a chance to refute whatever evidence has been given by these witnesses against him that he wishes to refute. His version will be before the commission, but it may well be that partly because his condonation application might not be adequate, it may well be that he doesn't get leave to cross-examine them. But that is different from a situation where it's only going to be their version of what happened. So in other words, it's different where he is nevertheless going to be able to put his version, tell the public his side of the story, so that it won't just be their version, but he might just not get the leave to cross-examine them. But when one looks at that, one looks at the fact that the evidence leaders do question witnesses, and these witnesses were questioned. But obviously, one is not saying that is the same as cross-examination. On a lighter note, I want to say that if I were to think of granting leave, the fact that you have indicated that you might need no more than an hour and a half would be an important incentive for me to grant leave. Not only that, but because if you would be doing the cross-examination, I happen to know that you go straight to the point. You don't waste time. So that would have counted in his favor. But I think I have difficulty because of the condonation issue.
Chair, ultimately, we're in your hands.
Yes.
Might I just indicate 2 points? The one is that obviously a commission is not to be rigid in its approach. It's an investigative exercise, and ultimately the South African public requires to know the truth of these matters, and the executive to be properly advised arising out of this. So That's the first point we would really would like to make. The second is, as you say, Chair, we are really pointing to a very limited and narrow area of interest. And to make the point which is right, cross-examination serves a different purpose than parties put in their versions. It is really intended to test the correctness of a version so that on a balance of probabilities, you ultimately, as a commission, would make determinations arising from it. But intelligence is one of the core issues I would submit are the matters this commission is going to get itself entangled with.
Would those be your submissions?
Those would be our submissions.
Yes.
As I say, with Njenje, we make those points. The areas are clarified where we want to go with him.
Yes, yes. If reasons are requested, they will be given, but the application for condonation is refused.
To the chairperson, please.
Thank you. Okay, all right. But as I indicated, the intention on the part of the commission is that Dr. Pole should get a chance to put his side of the story. Okay.
We indebted to you, Chair.
Okay. Thank you. Please call the next matter.
Verkmans Inc. in respect of the evidence of Mr. Montana, SCQ 45 of 2020.
Yes.
Good evening, Chairperson.
Good evening.
Ross Hutton for Worksmans. Chairperson, to a certain extent, we've anticipated the approach that you've taken in relation to most of these matters tonight.
Yes.
Could I, with your leave, read out a very short statement that Worksmans has prepared in relation to their application?
I'm not sure about reading out a statement because I'm expecting you to tell me if you are moving for the application or you are withdrawing the application. If you are moving the application, obviously you can then present argument. That's what I'm expecting.
Chairperson, we're not going to pursue the application.
Okay.
But I'd like to give you the reasons in a very brief statement.
Yeah, do so.
Worksmans has decided not to pursue its application to cross-examine Mr. Montana. After having listened to Mr. Montana's viva voce evidence and having had regard to his affidavit, Worksmans is satisfied to rely upon the content of the two affidavits that it has filed with the Commission, which deal with inter alia the allegations raised by Mr. Montana. Mr. Montana has levelled the most audacious and scurrilous allegations against Worksmans, yet he's failed to produce a scintilla of admissible evidence to corroborate his self-serving, injurious attack on Worksmans. The judgments handed down in relation to both Swefambo and Siyangena have vindicated the stance adopted by the then Board of Control under the chairmanship of Dr. Malefi, which sought to identify and bring to book those individuals and corporations who engaged in a feeding frenzy of unlawful behaviour to the detriment of PRASA and the commuters who rely upon this vital service. Worksmans remains proudly committed to the legal fight against the scourge of corruption which continues to plague our country and will not be deterred from so doing. And if we could simply leave it at that.
Yes, and the application is withdrawn.
That's
Is that right? Yeah. Okay, thank you.
Thank you.
Thank you. Next matter. Who is that? Oh, go to the podium, Mr. Montana.
Chair, thanks very much for the opportunity.
Yes.
And I've been here, Chair, I've been notified.
Yes.
And of course, I'm glad that I think Advocate Menyasi did explain the nature of this process, Chair.
Yes.
So if it was a court process with the rules and everything, I wouldn't be standing here.
Yes.
Chair, I think, of course, we've dealt with 3 matters already. This is the 3rd one. We've dealt with 2 matters. I was disappointed, of course, that it's the commission that speaks for the other people, because I would have laughed. I've been asked. I have a family bereavement. And I came here, Chair, to honor the request from the commission.
Oh, okay. You
And
talk
so-
about Mr. O'Sullivan.
Van Lorenberg, O'Sullivan,
Yeah.
and then this 3rd one, Chair.
Yes.
Because if indeed it was going to be withdrawn,
You would not have come.
I should have been informed.
Yeah,
But Chair, the Worksman's, I call it Worksman's, has been granted the opportunity to make a statement. And I think, Chair, for the same 2 minutes or 3 minutes of granted, I want to ask to be given the opportunity. And I'm glad, Chair, because the last time they stood, Worksman's indicated they want to cross-examine me. And I said I welcome the opportunity to be cross-examined.
Yeah, you said you are ready.
I'm ready, Chair. And today I was coming here not to oppose, but to mention 3 things, Chair.
Yeah.
But
remember, Mr. Montana, to the extent that you may already have said your piece about them, whatever they may have said was to respond to that.
No, Chair.
Yeah.
You remember at the time, I haven't testified, Chair. I haven't been led on my evidence.
Yeah.
I don't know the rules. In fact, Chair,
Yeah.
last week, I watched this commission. And I was so unhappy, Chair. Because for me, irrespective of, I just want the rules to be applied consistently. I came to this commission.
Okay, let me give you the 2 minutes you wanted.
Thank you, Chair.
Use it for the purpose of you wanted to respond.
Of addressing
Yeah.
Versman's,
Yeah,
Chair.
let's do
Chair,
it.
I mentioned 3 things about Versman's in my affidavit. The first issue relates to how they were appointed. That they were appointed not only irregularly, but they were appointed fraudulently. And Chair, there are documents, including the Auditor General's report of 2016. I was going to stand up here to say, Worksman, that was issued in 2016. There was another one in 2017. Worksman didn't challenge those reports by the Auditor General, a Chapter 9 institution. And in fact, I quote in detail in my own application, in my own affidavit. And actually, I'm shocked to hear someone standing here and saying there was no evidence. I provided even letters, including detailed emails, that shows that this legal firm that claims to be fighting corruption in the country is at the heart of corruption. Their appointment is in fact the most corrupt. So that's the first issue, Chair. And that is why I was waiting. And Worksmen know that they couldn't sustain this lie. The second issue, Chair, I've mentioned, again, based on evidence, I've said this legal firm was not only paid monies, but companies that are contracted to them, not contracted to PRASA, have been paid monies. I provided, so I was waiting for them to challenge that. They're not willing to do that. Finally, Chair, I produced reports of Worksmen's where I said, in their own reports, not somebody else's reports, where they said they will conduct surveillance. And I provided those reports that shows the amount of surveillance on over 922 entities and over 1,000 individuals. So, Chair, I was willing, but I'm glad today that they withdraw and they make a statement, which is a political statement, Chair, it doesn't assist you. But Chair, I'm glad that Van Lochrenberg has withdrawn. I'm glad Werksmans has withdrawn. And I'm just asking the commission to now provide me with a date for me to be led on my evidence. That's all I'm asking for, Chair. Thank you very much.
Thank you, Mr. Montana. Registrar, call the next matter.
General Pierre, in respect of the evidence of Mr. Van Lochrenberg, SCQ 42 of 2020.
Good evening. Please switch on your mic.
Good evening, Judge. It's Maniklal, initial
Yes.
R. I've been here
Yes.
before.
Yes.
Judge, I've listened to Judge's sentiments expressed earlier with Mr. Mukhari.
Yes.
And Judge would note that there was a request for information from the Commission in relation to Lebeya, and that, Lieutenant General Lebeya, that is, and that has been supplied comprehensively. And Judge, there was also a request for information and an application to cross-examine in respect of retired Colonel Lochrenberg. And Judge, in the reply and the application, which has been combined, would find the section that has been dealt with contains two annexures, which comprehensively indicate it's two letters. The first one is dated the 7th of August 2014. It should be the last page. And that is the exception or the acceptance of the extension of term of office from the 1st of November 2014.
I'm sorry, what paragraph is that?
It's the last annexure to
It's an annexure to,
General Pierre's affidavit relating to Lochrenberg.
or must I look at the last page of that
Yes, the
annexure?
last two pages, Judge.
Yes, okay.
The last page is dated the 7th of August 2014. And it is the acceptance of the extension of the contract from the 1st of November 2014.
I'm sorry, are we looking at the same file? My last document is an SAPS letter addressed to the Executive Director of IPED and signed by Major General E.N. Hlahla. Are we
Sorry,
looking at the
Judge.
same thing?
May I have leave to approach my learned colleague if we are in fact dealing with the same
Yeah,
document?
okay.
Judge, I've been advised that it's index page 11.
Oh, okay. Yes, okay, I've got it.
Does Judge note the
That's a
letter?
letter from C.N. Mbekela to Lieutenant General Ngobeni. Is that correct? That's the one on page 11. Right numbers, page 11.
Judge, my colleague tells me otherwise. It's the annexure after the affidavit.
Okay, do you have General Pierre's first page of her affidavit being marked 001 in red numbers at the top?
Yes, that is correct, Judge. The
I
next
must go
page.
to the end of that paragraph, of that affidavit. Must I go to the end first of that affidavit?
Yes, Judge.
To get
End
to
of
the
the
annexure that you want?
That is correct, Judge.
Okay, the last page of that affidavit is at page 10, red numbers, 010.
Yeah.
Right? Then at 011, it's this letter from C.N. Bekela to Lieutenant General P.M. Ngobeni.
Yes, there should be one more letter, Judge. The
And
next
then there is another one at page 12, which is the next page, addressed to Mr. McBride.
No, they mixed the letter up, Judge. May I?
You have a different one.
I have a different one. It's a different one has been supplied.
Maybe what we can do is we could go to another matter while you and your colleague try to sort this one out.
We will, Judge.
Registrar.
Thank you.
Registrar, did you skip the matter of M. Mukhatle versus J. Poison? Did you skip it? Is it the next one now? That one has not been withdrawn, has it? Okay. Why don't you call it? Okay, so let's put that on record. The matter of M. Mukhatle versus J. Poison, I understand, is postponed to tomorrow. Okay. Okay, then call the next matter.
Mr. Nair, in respect of the evidence of Richard Leroux, SCQ 20 of 2020.
This is an application by Mr. Nair for leave to cross-examine Mr. Leroux.
Thank you, Chair. Chair, we received a letter from Magistrate Nair's legal representatives this afternoon, and I'm advised that a copy has been availed to you. In essence, Magistrate Nair's legal representatives indicate that they only became aware of the sit-down for today's hearing early this afternoon.
Yes.
They also indicate that Magistrate Nair persists with his application if he is called to testify by the chair. They also indicate that if he will be called by the chair to testify, that they then seek that today's hearing be postponed to a date on which their counsel would be available. Chair, to the extent that Magistrate Nair's legal representatives indicate that they would only persist with the application if Magistrate Nair is called, the Chair would recall that on the 21st of July 2020, Magistrate Nair's evidence was called and was postponed for the purpose of the Commission and his legal team exchanging affidavits. And so, insofar as the Chair is concerned, Magistrate Nair is a witness who has been called to give evidence. And so that wouldn't necessarily be a ground on which they can base their application. And to the extent that they seek a postponement, we haven't received any formal application in this respect, but would be in the Chair's hand. And insofar as the application itself, Chair, as the legal team, we have no intention of opposing it. In fact, we are of the view that it would assist the Commission's proceedings. And insofar as the request for postponement by way of this letter, we are in your hands, Chair.
Well, just so that whoever reads the transcript at some stage would know that who was speaking, that it was somebody who from within the Commission. Maybe you must just place yourself on record to say you are from the legal team.
Certainly, Chair. I appear on behalf of the Commission's legal team in respect of the Bosasa work stream of evidence.
Well, I think that I would be disinclined to grant Mr. Naya leave to cross-examine because, if I recall correctly, he provides an explanation in his affidavit when he puts up his version, which doesn't appear to be disputed by Mr. Leroux. But I'm not sure, but in terms of disputes of facts, I seem to think that the position was that some security installations were done and by Busasa or one of their subsidiaries in his house. What remained was why they were done. I can't remember whether his version was that he asked them to do the installations and he paid them himself, in which case, unless there was evidence to the contrary, I would expect that to be the end of the matter. What's your recollection? There seems to be common cause that security installations were made in his house. So, in regard to the evidence of Mr. Leroux and Mr. Agrizi, with reference to other places where they made security installations, there were certain issues because certainly those people did not, as I recall, say we paid and so on. Do you recall his version? In other words, one would be looking at, are there disputed facts, and if so, what are those disputed facts between the two versions?
Thank you, Chair. In essence, Magistrate Ne disputes Mr. Leroux's evidence on 4 grounds. First, he denies ever meeting Mr. Leroux. And that is relevant insofar as Mr. Leroux was the head of the so-called special projects that Bosasa handled insofar as important persons to Bosasa, big ministers and ANC members, as according to Mr. Leroux. Now, on that score, Magistrate Ne denies firstly being part of the special projects because he does not fit into the category of either minister or ANC member. Secondly, he disputes that the installations at his house were done pursuant to a corrupt motive or reason. Thirdly, he disputes the dates on which the installations took place. And so, yes, as the chair initially put, he does not deny that installations were done at his house. He just denies the circumstances around which they were done. And then he also disputes that he ever met any other Bosasa employee. He states to have dealt with only one person who was indeed employed by Bosasa at the court at which Magistrate Ne sits. As this particular person was working under a contract that Bosasa had been awarded by the court in particular. Magistrate Ne goes as far as saying that this was a private arrangement between himself and this particular person. And all of this, Mr. Leroux has denied. He has insisted that it was pursuant to the special projects.
Does Mr. Naya say he paid for the installations in his house? Because if the position is that, excuse me, Bosasa if he admits that Busasa or a subsidiary of Busasa was installing security installations at the court, and then he made arrangements with Busasa to also make installations, security installations in his private house, the question would arise whether he paid for it. Does he deal with that?
Yes, he does. If
Yeah.
I might refer the chair to page 15 of the application,
Yeah.
in particular from paragraph 14
Well,
and following.
This does not appear to be Mr. Leroux's response. His affidavit, Leroux, is not paginated, but you say I must go to page 15.
Can we start at 14, please, Chair?
Yeah.
From paragraph 14 of
Yeah.
Magistrate Nair's affidavit. There he speaks about the contractual basis upon which he agreed to with Mr. Beju. Mr. Beju is the particular employee of Sondolo who
Yes.
was employed to work under the court's contract. He says there that there was an oral agreement that they entered into for the installation of a basic camera system and to repair the existing electric fence. He then goes on to say that it was at an agreed maximum contract price of 50,000 Rand. He goes further at paragraph 15 to say that the contractor never complied with his contractual obligations and says that in fact the security installation was not done as per the agreed terms and that it included the installation of equipment that was faulty and or not functional and or was installed at positions within the residence that was in direct conflict with the agreed contractual terms. Insofar as the payment at paragraph 16, he says that at no stage was he made aware or did he request Mr. Beju to install equipment at an excess value of 50,000 rands. He also says that he was not provided with an invoice and at no stage was he informed that the budget would be exceeded. He then says that in any event, in absence of proof regarding the cost of the equipment, that he disputes the amounts that were alleged by Mr. Leroux. He then also says that Mr. Beju was called upon to remedy the situation and that this never happened. Mr. Nair then says he eventually resolved from the agreement and subsequently caused the contractual deficiencies in the installation to be remedied by a third-party contractor. He then says he denies any implied involvement in state capture and so forth. So he doesn't say in his affidavit that he actually paid for the costs of the security upgrade.
And it doesn't say that he returned the whatever had been installed.
That is correct, Chair. That is correct. He only says there at paragraph 16 that he had to call on a third party to come and remedy what had been done at his residence.
Yeah. Well, I think what I think has a date been fixed for Mr. Nair to give evidence?
Not yet, Chair. We await your direction.
Yeah. Okay. A date will be given, and I think what I should do is postpone this application and let Mr. Nair tell his version, take the witness stand first, and after he has finished his evidence, I will see what disputes of facts remain between the two versions, and then decide the application after that. I think arrangements will have to be made for Mr. Leroux to be available, so that if I grant Mr. Nair leave to cross-examine him, he would be available.
Thank you, Chair.
Yeah. So this application is postponed.
Thank you, Chair.
Okay.
May I please be excused?
Yeah, you are excused. Please call the next matter.
Baloyi, in respect of Robert McBride, SCQ 33 of 2020.
That matter, is that one of the matters postponed to tomorrow?
Correct.
Is that a yes?
Yes.
Okay, that matter is postponed to tomorrow. Yes.
Advocate Mashuga, in respect of Robert McBride, SCQ 35 of 2020.
Is that one of the matters postponed to tomorrow?
Correct.
Okay, that matter is postponed to tomorrow. Next.
AfriForum, in respect of President Ramaphosa, SCQ 16 of 2020.
What about Memela, which appears before AfriForum?
Ms. Mamela and Mr. Mamola Piri, SCQ 36 of 2020.
This matter, this application has been withdrawn. Right, next matter.
AfriForum, in respect of President Ramaphosa, SCQ 16 of 2020.
Okay. Yes.
Good evening, Chair.
Good evening.
My name is Mia du Plessis. I'm from the Johannesburg Bar and I appear on behalf of AfriForum.
Yes, okay. I think there's appearance for the legal team as well. Thank you, Mr. Pretorius. Yeah, do that. The registrar, I will just call this matter the AfriForum matter again.
AfriForum, in respect of President Ramaphosa, SCQ 16 of 2021.
That is the application by AfriForum for leave to cross-examine Mr. Ramaphosa. Yes.
That's correct, Chair. Chair,
Yes.
for your convenience, I prepared a bundle containing our heads of argument together with our application and the relevant sections of President Ramaphosa's testimony that we referred to. May I beg leave to hand it
Okay.
up?
You. I've read the papers in this matter. The first difficulty I have with it is that in order for a person to apply for leave to cross-examine a witness in terms of the rules, that person must be implicated by that witness. When I read AfriForum's application, I do not remember seeing anywhere where they say President Ramaphosa is going to implicate them. Is that correct?
That's correct, Chair.
Yes. So in that, if that is correct, how does AfriForum, out of everybody in South Africa, qualify to apply for leave to cross-examine? Because everyone who applies for leave to cross-examine does so because they are implicated by that witness.
Is this the only issue Chair would like me to address you upon?
Yes, do so, please.
On behalf of AfriForum, I would just like to express our sincere gratitude for being afforded this opportunity today. We do understand there is severe time constraints on the Commission, and we also appreciate the fact that there is still a magnitude of work to be done by the Commission. Chair, AfriForum takes cognizance of the fact that this application does not fall within the scope of Rule 3 of the rules. However, we are relying on the provisions of Rule 11, which state that, I quote, any party wishing to make any application to this Commission, which is not otherwise provided for by these rules, must do so on at least 7 days calendar notice. This rule is relied upon in congruence with Section 38D of the Constitution, in terms of which, I quote, anyone acting in the public interest may approach a court for relief arising from the infringement of threatened infringement of a right in the Bill of Rights. Further along our arguments, I will also elaborate upon the relevant authorities on this subject, but with your leave, Chair, I would just like to make one or two submissions with regards to our standing today. First,
do that, but I want you to understand that if the rules say, as I think you and I agree they do say, you have to be an implicated person in order to apply for leave to cross-examine a witness. If you are not an implicated person, it means you fall outside the category of persons who may apply. And that, it seems to me, is for a good reason. Because if it were to be otherwise, then anybody and any organization in the country that feels like we would like to cross-examine so and so, they can apply too. And you know that so many organizations have got in their constitutions or founding instruments something that allows them to do a lot of things. So one, even when it comes to somebody who is implicated, they are not given the right to cross-examine. They have to apply. And I must decide that in terms of the rules based on the interests of the work of the Commission. And you must remember that this is a situation where there would be an evidence leader of the Commission, a lawyer who would be questioning that witness. And that lawyer who would be questioning that witness, in terms of the rules, is entitled to question the witness with a view to establishing the truth. You see?
Indeed, Chair,
So
I completely agree with you, Chair.
when you have regard to that and the time constraints, then it becomes difficult to say it's in the interest of the work of the Commission for me to grant AfriForum leave to cross-examine. You see what the problem is. Tomorrow somebody else is going to say, I also want to cross-examine the president. Another one will say, I also want to cross-examine. It's floodgates, opening a floodgates.
I understand that, Chair.
Yes.
Chair, all the issues that you just raised now, I have answers for those questions. I've prepared an argument to this effect.
Yeah.
And AfriForum is an objective party to these proceedings and a friend of this Commission. And in terms of our submissions, we do not say that the Commission is not performing their work. We are merely trying to assist the Commission on very specified issues.
Well, what I can tell you is that there is nothing preventing you, of AfriForum, or anybody to bring something to the attention of the legal team, for example, to say, with regard to a certain topic, here is our suggestions of issues that we would like the Commission or the evidence leaders to seriously consider pursuing. Obviously, ultimately, it would be up to the evidence leader what to do, but making those suggestions, nobody has said you can't. But cross-examination is something else.
Would you be inclined to hear the rest of my submissions?
Well, I would like you to address the concerns that I've raised.
I will do
Because
that.
if you persuade me on them, maybe I can listen to the rest. But if you don't persuade me on them, then there is no point in going further. But I can assure you that I have read AfriForum's affidavit in full.
Did you receive my heads of argument, Chair?
I have not read your heads of argument.
It is all there in the bundle that I prepared for you.
Yeah, okay, all right. But those are my primary concerns.
I understand
So
that, Chair.
I give
completely
you,
understand.
is it fine if I give you 10 minutes to
10 minutes is
address them?
perfect, Chair.
Yeah,
10
okay,
minutes is
do
perfect.
that.
Firstly, Chair, it should be recorded that the applicant is an independent civil rights association. AfriForum's got more than 280,000 members of the public and their families. I'm sure that you are well aware of the work done by AfriForum for the community, so I would not elaborate upon the organization's work on this subject. Secondly, Chair would have noted that in our initial application, which was placed before this commission, we aimed at placing evidence before the Commission by leading oral evidence on the Cadre Deployment Commission. The evidence leaders in leading evidence on the subject matter, Advocate Pretorius and Advocate Friend, did however question President Ramaphosa at great length, and I must admit we couldn't have done a better job than that. However, it did transpire from President Ramaphosa's testimony that in consideration of his answer to specific questions proposed to him by your team, and to a certain extent by yourself, Chair, the fact is that the public is still left with a great amount of uncertainty in certain regards.
But you must remember that he is still coming back.
I understand that. I understand that, Chair.
When he comes back, there are still some outstanding issues that he must deal with in his capacity as president of the ANC, and thereafter give evidence as president of the country. So he's not done.
I understand that, Chair. Chair, if we look at the constitutional matters of Ferreira versus Levin, that was a 1996 matter. Then also the Lawyers for Human Rights matter, it was a constitutional matter in 2004. And then Limpopo Legal Solutions versus Bempi District, where you delivered unanimous judgment in favor of the applicants in your capacity as Justice of the Constitutional Court. It becomes evident from the previous matters I referred to that Section 38D creates an opportunity for any individual or any group to approach a court if moved by the desire to benefit any portion of the public. Furthermore, Chair would note from our heads of argument that we make mention of the proposed recommendations of the South African Law Commission with regard to public interest actions, in terms of which it is proposed that this scope of standing is required for litigation of a public character where the relief sought is generally forward-looking and general in its application. Chair, in line with the aforesaid, we would submit that the provisions of Section 38 would therefore allow us to act on behalf of our members based on the foundation of their human rights. We appreciate the fact that this is not a normal court. It is a commission of inquiry indeed. Premised on the constitutional rights of the public, however, we bring this application before this commission based on our constitutional rights in terms of dignity, equality, and most importantly, is the rights against unfair discrimination. I understand that you might at this stage ask me, well, how are we going to assist the commission in its work? Chair, the answer is quite simple. Our Free Forum, as an objective party acting within the interest of its members, is a friend of this commission, and as I stated in my opening address to you, Chair, we are well aware of the magnitude of work done by the commission already and still needs to be done by the commission. But we aim to ease the burden of the commission by assisting. We did make our best attempt to eliminate the important issues relating to the catered deployment to the bare minimum, and I will point them out to you shortly. We do submit, however, that the public is directly affected by the allegations of state capture, by fraud, by corruption, and as electorates of this community, we respectfully submit that we should be entitled to satisfy our curiosity in this regard. And by clarifying certain issues with President Ramaphosa in his capacity as the leader of the ANC. The specific portions of President Ramaphosa's testimony which raises concern amongst our members are the following. In his opening statement, President Ramaphosa, in aim of a remedy of the past events, the view of the ANC is that the ANC's complicity in this regard is acknowledged, and these problems ought to be dealt with by the ANC. Our line of questioning in this regard would specifically pertain to the promises made by President Ramaphosa during his first New Dawn opening address to the nation, and also whether the current state of our country has improved to this effect. President Ramaphosa further elaborates upon the statement and says that even before the advent of democracy, that the ANC said that in transforming the public service to reflect the values of our democracy, or better still, the diversity of our country, that we must emphasize professionalism and competence. I quote from page 27 of the 28th of April transcript in front of you. It is the ANC's view that the practice of catered deployment should not be inconsistent with the principles of fairness, transparency, and merit in the appointment of individuals to public entities. Catered deployment cannot be faulted in principle. When Advocate Pretorius proposed to President Ramaphosa that there has been evidence that the deployment policy goes far beyond mere recommendation, President Ramaphosa denied this and stated that the Deployment Commission merely recommends. In this regard, Chair, we would like to hear from President Ramaphosa his comments on the testimonies provided by Mr. Johnson, Mr. Salfi, and Ms. Barbara Hogan. We refer to these certain portions of the testimonies in our affidavit. Chair, on page 45 of the 28th April transcript, we specifically ask you, Chair, ask President Ramaphosa on the importance of the Deployment Committee opposed to mere identification of potential candidates. And in our opinion, the answers provided on this proposal were vague and begs for clarity from the President. Furthermore, it was proposed by yourself to President Ramaphosa that the candidates recommended by the Deployment Committee might have an unfair advantage, if I interpret that correctly. President Ramaphosa responded to this, and I quote, "We are a political organization, and what we do in government is very political. So you do need that political filter that will go ahead and appoint people who are not fit for purpose." Chair, with all due respect, we found this statement extremely confusing. Then at page 75, Advocate Pretorius proposed to the President that a certain view has been expressed before this Commission that there is no need for a Deployment Committee anymore. And then Advocate Pretorius referred the President to the testimony of Ms. Barbara Hogan. And specifically, I quote, "How can just a handful of people possibly have the institutional knowledge and resources to pronounce on suitable candidates for every senior position in government and the private sector. This quote, Chair, lays the foundation for the very essence of our argument today, specifically in relation to our constitutional rights against unfair discrimination. What is more important, and I'm almost done, Jay. I can see you looking at your watch.
I'm
nearly done.
I think you are left with 2 minutes.
What is more
Yes.
important and our biggest concern in this regard is President Ramaphosa's answer, and I quote, "When dealing with these types of matters, it is better to be circumspect and not to throw the baby out of the bathwater, because if there is something that causes an irritation, it does not mean that you chuck everything out because the deployment committee has a number of considerations that it needs to keep in mind." Chair, with all due respect, we would like to know where that leaves us on the way forward. Does this mean that the future holds the same prospects as the events of the past? In talking about the past, and on page 71, Advocate Pretoria specifically raised the question on how experiences of the past could be prevented from happening again, whereby President Ramaphosa proposed regulation at state level and a renewal process. Chair, because the future and the economy of the country, as well as the democracy of the country, is important to all of us, we submit that we desire to partake in the development of the regulations, and specifically the said renewal process. We would like to know what these regulations would look like, and we would like to give our input in our capacity as electorates of the country, and then we can also make more informed decisions when casting our votes. In conclusion, and once again, an absolute cause for concern raised by the members of the applicant is that President Ramaphosa, in his closing statement, and I quote, "We are mindful of the fact that the mandate of the Commission does not extend to how political parties must function, and that it is the sole prerogative of political parties themselves, particularly the ANC, to determine their own organizational arrangements, and some of the thoughts and the suggestions that have been put there, obviously we will reflect on with a view of seeing how best we too can improve the way we function. With respect, we submit that the statement contradicts the opening address to this Commission, and we seek clarity on where this leaves us, Chair. I'm ending my argument by stating that the Constitution creates a structure of accountability between the voters, which is us, the National Assembly, the President, and the Cabinet. Cater deployment to a big extent disrupt every link in this chain of accountability.
Thank you.
Chair, I'm going to cut myself short there and say that we stand by the submissions made in our aids of argument, and we pray that the Chair would grant us leave to participate when President Ramaphosa comes back in front of the Commission.
Yes, no, thank you.
Thank you, Chair.
I don't intend hearing you, Mr. Pretorius. You already have an idea of some of my preliminary views. I gave you a chance to address me. Insofar as AfriForum wanted President Ramaphosa to be called as a witness, he has already been invited, and he came, and he will still come back. But insofar as AfriForum wanted leave to, or asked for leave to cross-examine him, that application is refused. If AfriForum insists on reasons, they can write, and the reasons will be given.
Thank you, Chair. I appreciate your time. Thank you.
Thank you. Okay. Next matter.
I recall the matter of General Piega and in respect of the evidence of Mr. van Lochenberg, SCQ 42 of 2020.
Yes, you are back.
Thank you, Chair. Chair, we have confirmed that the annexure was sent to Mr. Hali, but unfortunately didn't find its way to my learned friend.
Yes.
But nevertheless, Judge, it's been dealt with in the annexure that's before Judge, the ones dated the 21st of September 2014, on page 11.
But is the annexure, is there a copy that has been given to me or not?
Judge, it hasn't been given to you, but maybe we have leave to.
If you have another one, yeah, okay. Yes.
Judge, essentially, there the Provincial Commission had accepted the extension of the contract for 5 years in August of 2014.
Yes.
And
You started off your address by saying you took note of the remarks I made earlier. You didn't proceed to say what you make of them in the context of this application.
Judge,
Do you want to help me out with that first?
Yes, Judge. In the context of the application and based on Judge's remarks, I have taken instructions in the meantime, and the application can safely be withdrawn simply because Judge has already made the comments the Judge did, which doesn't deserve repetition.
Yes.
Except, Judge, if you accept into evidence that letter and the letter preceding that, the one you referred to on page 11, Judge, that is where the letter dated 21st of September 2014.
Are they annexures to her affidavit?
That's an annexure to her affidavit.
Yeah, if they are annexures to her affidavit, that's fine, because then they are part of the affidavit.
Yes, and then Judge will accept that on that basis, the entire issue of expecting a report from the Provincial Director of Public Prosecution that the witness testified to falls away, Judge.
Well, within the context of the remarks that I made, I think what you are saying is you are happy to withdraw the application in the context of those remarks.
Yes.
But the affidavit with its annexures remains obviously with the Commission.
Yes, Judge, and that dispels the aspersions that were cast on General Piega during the course of the evidence of Lochrenberg.
Yes.
This safely dispels it completely, Judge.
Yes. So the position is that you would accept that since her affidavit is before the Commission, putting her side of the story with the annexures, that should be adequate.
That should be adequate for Judge to make the actual findings.
Yeah, well, in the context of those remarks is that I might not make any finding either way, but at least the version is there. If I want to say anything, I will have regard to all versions.
It's completely there.
It's complete, yeah. Okay, all right. So can I note that the application is withdrawn?
That is correct, Judge.
Okay. I note that this application has been withdrawn. Thank you. Next matter.
Ms. Mamela, in respect of the evidence of Mr. Sambo, SCQ 4 of 2020.
This matter, this application has been withdrawn. Please call the next matter.
Ms. Mamela, in respect of the evidence of Mr. Human, SCQ 5 of 2020.
This application has also been withdrawn. Call the next matter.
Mr. Zulu, in respect of the evidence of Mr. Dukwana, SCQ 42 of 2019.
The one of Mr. Pahlane versus Sisoko has already been withdrawn, is that right? Yeah, when we dealt with it was, we dealt with it on the basis, we dealt with it on the basis that it had already been decided. There would be no cross-examination. Okay, so what is the next matter?
Mr. Zulu, in respect of Mr. Dukwana, SCQ 42 of 2019.
Ms. Rangata?
Chair, within the Free State work stream, there's an application that was brought by Mr. Zulu to cross-examine Mr. Dukwana. The application has since been withdrawn. We have been finished with a letter yesterday on the 14th of June 2021, indicating the mandate by the attorney, Ndobeko Tlamini Incorporated, to withdraw the application to cross-examine Mr. Dukwana.
Yes.
Yes.
Okay, so that application has been withdrawn.
Yes.
Okay,
Thank you, Chair.
Thank you. Next matter.
Advocate Jeepa, in respect of the evidence of Mr. Agrisi, SCQ 03 of 2019.
There is nobody appearing for the commission there, but this application, there was a request for it to be adjourned. Did I fix a date, Registrar? What date have I fixed for it?
The 22nd of June.
What time? Sorry?
At 10.
23rd of June.
22nd of June at 10.
This application has been adjourned to the 22nd of June at 10 a.m. Next matter.
Mr. Putalesi, in respect of the evidence of Mr. Popo Molefe and Mr. Ryan Sachs, SCQ 17 of 2021.
Yes.
Good evening, Chairperson. It's Vuyani Ngalwana for Mr.
Good evening, Mr. Ngalwana.
It's been a long wait, Chairperson. A long and
You have not
freezing
appeared
wait.
before this commission in a very long time.
Yes.
I think the last time you appeared, we were still in the other venue. Or did you
Yes,
appear
quite
in this
so.
venue?
No, this is the very first time and hopefully the last. It's freezing here. Chairperson, thank you for the indulgence of hearing us.
Yes.
I note that you are yet to grant a single of these applications. I'm hopeful that the fortunes of my client will be different.
Well, you have already said you hope not to come back here.
Well, I need not come, but someone else may. Chairperson, you will have noted, I'm not sure if you've received my client's application. It's in fact different from the usual applications one gets because we are not eager, we're not come here out of eagerness to embarrass anybody or to expose anybody's evidence. But we are here to ensure that the evidence leaders do their job as they are supposed to do them. You will have noted that the manner in which the application is phrased, maybe not in the notice of motion, but certainly in the founding affidavit, is we ask the evidence leaders to take an opportunity to probe the probative value of the evidence that was given to them by Mr. Sachs on the one hand and Mr. Popomolife on the other. If they should be either unwilling to do so or they should fail to do so, then we offer our services to perform that task. That is all we are asking. We're not eager to joust at the sword, as it were. We simply want the evidence to be properly probed. Having said that, I'm wondering, because usually when one brings an application, one is told whether or not the application is opposed or not.
Yes.
I haven't heard any word as regards whether Mr. Sachs is opposing the application or Mr. Popomolife is opposing the application. What we have received yesterday was a 10-page affidavit deposed to by Mr. Sachs,
Yes.
in which he seeks to distance himself from his own evidence.
Yes.
Because he says, well, that was not my evidence, that was the evidence of Mr. Molapo or something, or Moloto. Or that this was evidence that was contained in his report to the Hawks, but it's not his own evidence. There is though one aspect which he stands by, and he says it's his evidence, that is that there had been a disbursement of some 99 million rand to Sebenza by Swivambo or something to that effect, and alleging that my client, Mr. Buthelezi, may have benefited from that largesse by his association with 3 companies. And Mr. Buthelezi has set out clearly in his affidavit that Sebenza only received a princely sum of 3.5 million of the 100 million rand that Mr. Sachs is testifying to. So, Chair, regards Mr. Sachs, I've heard what you said earlier to other persons who were standing here before me, that the fact that evidence has been laid doesn't necessarily mean that it is accepted holus bolus.
Of course.
That the person who has been implicated by the evidence may be given an opportunity to put his side of the story. Except cross-examination has, as you know, a different purpose.
Sure. It's not to say it takes the place of.
Absolutely.
Yeah, it's simply to say one must know that even though there might not be cross-examination, there will be 2 or more versions, which is different from there being no cross-examination and no other version.
Yes.
But it is not obviously to suggest that it takes the place of cross-examination.
Absolutely, Chairperson. Now, the point I wish to make is a brief one in relation to that statement that you have made. It is that sometimes a witness gives a particular version which is contrary to the version that the person he's implicated may give. But the cross-examiner may want to get to the reason, the motivation behind the witness giving that version in that particular way. That is not something one can address by simply putting one's own client's version on paper or on record. It is only something that the witness who gave that evidence in that particular way can explain. And that is where cross-examination comes in.
No, that is really, obviously, a place for cross-examination. It's a question of weighing up in each case to say, in this case, how important is it in the light of A, B, C, D, in the light of all the issues. Yes. But you started off by saying, in effect, as I understood you, although this is an application for leave to cross-examine, you really have no particular, that is your client, no particular eagerness. You have no particular eagerness to say we really would like to cross-examine at all costs if possible, but you have some concern about whether the particular witnesses were probed sufficiently.
Yes, Chairperson.
Yes, yeah.
May I phrase it this way?
Yeah.
Our interest is to see the truth being unearthed, not a version of the truth, not one witness's version of the truth, but the truth, objectively speaking.
Yeah.
And we are afraid, we feel that wasn't done in relation to Mr. Popomolife and Mr. Sachs.
Yeah.
Certainly as relates to my client, Mr. Sifiso Buthelezi. And so we are happy if the chairperson says, well, we will give whoever the evidence leader was, I can't remember now, an opportunity to probe the aspects that you have identified in your affidavit?
Well, that's really what came to my mind when you said that, to say it would be good to hear whether it would have been Mr. Soni. I think he
Yes,
would have
that's
led
the one.
evidence.
Yes, I'm sorry. Yeah.
It would be good to let him have the opportunity if he hasn't had. I know he's not appearing here today because he has been given, he's involved in another matter these days, not in the commission, to hear what his reaction is once he has read, if he hasn't already read this, and hearing your client's sentiment. If he says, well, having gone through this, I wouldn't mind probing further. It may be that your position would be, okay, let's leave it to, let's allow him to do that, and because we might be fine after that. And if he takes the view that, look, he thinks he has probed enough, then we can take it from there.
Yes.
So it may well be that I shouldn't decide this now. Maybe I should see if I can decide it in the next few days. But he would need to indicate what the position is. What I'm thinking at the moment is whether I could say, for example, let's adjourn it to, let us say, Friday morning this week for him and for you if you are available to come, and he indicates what his attitude is, and then we take it from there. I'm just choosing Friday. If you are not available Friday, we can choose another date, another day.
Well, I wouldn't have much choice. I didn't have much choice to come here today. I had to come from Cape Town to be here in person.
Oh, yes.
So out of respect for the chairperson, I didn't want to make excuses.
Yes, yes.
Chair, I would be amenable to that.
Yes.
And it would be preferable, of course, if we were to know in advance what the position of the evidence leader is, so that, if we come here, we could come here on a watching brief basis if he is to take up that opportunity.
Yeah. Well, you might or might not know, I'm going to hear a few applications for leave to cross-examine tomorrow. Tomorrow is a public holiday, but some of us will be working. And so I'm wondering whether, he could read tomorrow, and maybe arrangements could be made for him to be in touch with you to indicate what his inclination is. And then if, for example, he were to say, okay, maybe I should say either way, then maybe either Thursday morning or at some stage on Thursday, he can come here and let me know, or you two of you can come and let me know. And then if we have to wait because he is going to take the matter further, then we just adjourn until then. If he doesn't intend to take it further, then you address me on whatever else you wish to address me on, and then I can decide.
Well, I would have nothing more to address you on. Everything that we have to say
is what you have said.
Is in the affidavit.
It's in the affidavit, okay.
And if it's necessary, I might just, without reading, just refer you to the paragraphs.
Yeah, that's fine.
In relation to Mr. Sachs, it's really the aspects starting at paragraph, it's from paragraphs 39 to paragraph 46 of the affidavit.
Let me get there. 39
to 46.
to 46.
And in relation to Mr. Popomolife is from paragraphs 49 to paragraph 55.
In relation to Mr. Popomolife, it's from paragraph
49 to 55.
49 to 55.
And you will note there, Chair, and the manner in which we've set them out, it makes it easy for anyone, well, with a modicum of training in trial advocacy, to be able to see what questions need to be put.
I'm sorry, did you say 59?
To 55, from
55.
49 to 55 in relation to Mr. Molife. And so one will find that in relation to Mr. Molife, it's really 4 questions or thereabouts.
Yes.
And in relation to Mr. Sachs, it's 3 to 4 questions or thereabouts. And, But of course, one can't confine oneself because the way in which cross-examination works, you may ask a question and a witness may open himself up to another question.
That's fair enough. That's fair enough.
But it wouldn't, in my estimation, I heard you having that discussion with Mr. Simania, my senior.
Yes.
In my estimation, certainly if I were to do it, I wouldn't take longer than 30 minutes in relation to Mr. Sachs and maybe 40 minutes in relation to Mr. So the whole exercise wouldn't take longer than an hour.
Well, I can just tell you that it helps if I've had the opportunity to know that, to see you cross-examine because there I know so-and-so doesn't waste time. But I might not have seen you cross-examine, but the way you have addressed the issues is to the point.
Yes, thank you, Chair.
And I would imagine that the cross-examination, if granted, would be along the same lines.
It would be to the point, Chair. May I just say one last thing? It's unfortunate that in a commission setting we use words like cross-examination.
Yes.
And so it gives the witness an impression that he's going to be under the whip, but cross-examination need not be that.
It gives the impression that he's going to be examined crossly.
Absolutely. and cross-examination need not be like that. Maybe you may be given leading questions and you answer yes or no and it's done.
Yeah, no, that's true. That's true.
That will be all for now, Chairperson.
Yes. Okay, shall we say Thursday or Friday? From your side, you are, or he might be in, okay, I think because there is somebody representing him here, she will talk to him, and I think maybe we should say Friday. He might not be available himself because of the trial in which he's involved, but Ms. Rangata can come. But it can be Thursday as well, if that suits you better.
Thursday suits me better, Chairperson.
Thursday. Okay, let's say Thursday at 10 o'clock, just to inform me what the position is. Because you have nothing further to add on the merits of the application.
Of course, it depends on what he has to say. Then I doubt I'll have much more to add.
Yes, okay. No, that's fine. That's fine. Let me hear what Ms. Rangata has to say. Thank you. Thank you. Let them sanitize.
Thank you,
Ms. Rangata.
Chair. Thank you, Chair, and thank you for my brother. I'm very indebted for the guidance that you've given in the matter. I think it kind of short-circuit the issues.
Yes.
I should say that Thursday it suits me better. In case Advocate Sodi is not able to be in attendance, I will definitely attend on his behalf.
Yes,
So I can confirm that Thursday 10 o'clock should be proper.
Okay, no, that's fine.
Yes.
That's fine. Let's leave it at that then. So this matter is adjourned for now until Thursday at 10 o'clock.
Thank you, Chair.
Registrar, was that the last matter?
Chair, I think that's all the matters for the day.
Yeah, thank
Yes.
you. We are done then. Tomorrow, for the benefit of the public, I will hear, I'll be sitting and I'll hear some applications for leave to cross-examine that have been postponed to tomorrow. We adjourn. Thank you very much to everybody for their cooperation to be here until this time. Thank you very much.
Thank you,
We
Chair.
adjourn.